Hello and welcome to my channel Happy Hours. In the last video I discussed about the disqualification of Member of Parliaments, Anti-Defection Law, 91st Amendment Act 2003, Representation of People's Act 1951 and about the Governor. In this video I am going to discuss about the powers of Governor, the ordinance making power and the discretionary power of the Governor and about the state legislature. So what are we waiting for? Let's jump into the first topic for today, which is the powers and functions of the Governor. The Governor of a state enjoys all the powers that the President enjoys at the center except the emergency powers, diplomatic powers and military powers. Governor of the state enjoys executive powers, legislative powers and judicial powers. Now let us discuss all these one by one. Executive power. It is described under Article number 154. Executive power is vested to Governor of state. He has the power of appointments and removal in the state. Next is the legislative powers. Article number 168 clause 1 declares the Governor as a part of the state legislature. The Governor gives assent to a bill passed by the state legislature. The Governor summons and prorogues the sessions of the state legislature and dissolves the state legislative assembly. The Governor may address the state legislature and also send messages to the House or the houses of the legislature. The Governor addresses the legislative assembly or in the case of the state having a legislative council. The joint sitting of the both houses at the commencement of the first session after each general election to the legislative assembly and at commencement of the first session of each year. Under Article number 213, the Governor promulgates ordinance during the recess of the state legislature. Now let us discuss about the ordinance making power of the Governor. The Governor of a state can promulgate an ordinance at any time except when the legislative assembly of a state is in session or where there is a legislative council, except when both houses of the legislature are in session. The ordinance promulgated under Article number 213 shall have the same force and effect as the law of state legislature. The ordinance has to be approved by the state legislature within 6 weeks from the reassembly of the legislature, and it may be withdrawn at any time by the Governor. Now we should understand what is the difference in between the ordinance making power of a president and a governor. Under the Article number 123, the President has the power to promulgate an ordinance on a subject which is under the jurisdiction of the Parliament, that is, on a subject in the Union list and the concurrent list. On the other hand, the Governor has the power to promulgate ordinance on the subject which are under the legislative jurisdiction of state legislature, that is, on a subject in the concurrent list and the state list. But the Governor shall not promulgate an ordinance without the instructions from the President under the following conditions. First, if a bill passed by the state legislature is pending before the President after being resolved by the Governor for the reconsideration of the President. Secondly, on the subject on a concurrent list on which there already exists a central law. And the third, the Governor cannot promulgate an ordinance on a subject on his own if a bill containing the same provision or under the Constitution have required the previous sanction of the President for its introduction in the state legislature. Now let us discuss the legality of the re-promulgation of the ordinances by the Governor without placing them before the legislature. Ordinances are not a very healthy practice in a democratic country. It violates the basic structure of the Constitution and it undermines the doctrine of separation of power. It must only be used when there is the extreme case of emergency. If the ordinance route is unhealthy, the re-promulgation of the ordinances without presenting it before the legislature is worst. The mechanism could be used as an exercise of the power by the executive to ignore the legislature. The Supreme Court in the D.C. Badhwa and Krishna Kumar Singh versus Bihar case held that the Supreme Court said that the re-promulgation of the ordinances having the same text and without attempting to pass the bill amounts to violation of the Constitution. Judicial power of the governor. The governor of a state enjoys the same judicial power as the president except that the governor cannot pardon a death sentence. Now let us discuss about the discretionary power of a governor. Article number 163 clause 1 holds that there shall be a council of ministers with the chief minister as the head to aid and advise the governor in the exercise of its function except in so far as the governor under the constitution is required to act in his discretion. Article number 163.1 is generally compared with the article number 74 clause 1, but the article number 74 clause 1 is silent on the discretionary powers of the president, whereas the article number 163 clause 1 recognizes that the governor has some discretionary power. Article number 163 clause 2 holds that if any question arises that whether matter comes under the description of the governor, the decision on the governor is the final. Means the governor decision is the final decision. This article is one of the most misused power of the governor. The appointment of the chief minister in the case of hung assembly, that is, when no political party or a pre-poll coalition gets the majority in the state legislative assembly, then this power is misused. Dissolution of the legislative assembly and article number 200. After a bill is passed by the state legislative assembly or the state legislature, it is presented to the governor, who shall declare either that he assent to the bill or he withholds the assent or that he reserves the bill for the consideration of the president. Or in case of a non-money bill, he can return the bill as soon as possible to the house or houses for reconsideration only for once. And this here also again this article number 163 clause 2 is misused. The governor has to reserve any bill for the consideration of the president, which is in his opinion if it becomes law, derogates from the power of the high court as to endanger the position of the high court given to it by the constitution. Now let us discuss about the fate of the bill reserved by the governor for the consideration of the president. When a bill is reserved by the governor for the consideration of the president, which is described under the article number 201, the president has to declare either that he assents to the bill or that he withholds the assent, or in case of a non-money bill, he may direct the governor to return the bill to the state legislature for reconsideration. When a bill is so returned, the house or houses shall reconsider it accordingly within 6 months. And if the bill is passed again by the state legislature, it is presented to the president again for consideration. Sending a report, the governor of the state has to send a fortnightly report to the center with respect to the affairs of the state. Next, under the article number 356, the governor of a state can send a report to the president recommending president's rule or state emergency in the state on the ground of breakdown of constitutional machinery. In the state, it is also a misused article, the article number 356. Now let us discuss about the next topic, which is the state legislature. State legislature is made of two. sometimes like state legislative council and legislative assembly. It is in the sixth state, Andhra Pradesh, Bihar, Karnataka, Telangana, Maharashtra, and UP. And rest all of the state are having only legislative assembly. Now let us discuss about the legislative council. Maximum strength is one third of the total strength of the state legislative assembly, and minimum is 40. The term of the member is 6 years, and one third of the members retire every two years. Presiding officers, the chairman and the deputy chairman, are elected from amongst the members of the House by a simple majority and can be removed by the resolution of the House passed by a majority of all the then members of the House. Composition of the Legislative Council is one third of the member to be elected by the MLAs of the state, one third to be elected by the local bodies, means municipality and panchayat, etc., and 1/12 to be elected by the teachers, and the teachers should be the resident of the state, and they should not be below the rank of the secondary level, and they should be aware of it, and 1/12 to be elected by the graduates of the state, graduates who are already 3 years standing, and 1/6 is nominated by the governor from amongst the person having special contribution in the field of science, art, literature, social service, and cooperation movements. Now let us discuss about the creation and abolition of a legislative council. The process has been mentioned in the article number 169. A legislative council can be created or can be abolished by the parliament on the request of the state legislative assembly. Now let us discuss about the justification of the legislative council. First is functional representation. Second, availability of more members to be appointed as ministers. And third, strengthening of democracy. Fourth and last one is to put a check on the hasty legislations. Means the sobering effect of Philip sober over Philip drunk. Now let us discuss about the legislative assembly, where the maximum strength can be 500, minimum strength is 60. But the center can provide for lesser number of members for the some state assemblies. Like example is Sikkim, which is having only 32 members. Term is 5 years, can be extended during national emergency for not more than 1 year at a time. It can be dissolved before the end of its term by the governor on the advice of the state council of ministers, and by the president during the proclamation of state emergency in the state. There is a reservation for scheduled castes, scheduled tribes, and the women. The provisions regarding the presiding officers of the House is the same as the presiding officers of the Lok Sabha. Now let us discuss about the relationship between the state legislative council and the state legislative assembly. Generally speaking, the legislative assembly is considered superior to the council, as the existence of the council depends on the wishes of the legislative assembly. As far as executive is concerned, the member of both the houses can be appointed as the minister. The council of ministers is collectively responsible to the legislative assembly, and a no confidence motion and cut motion can be introduced and passed only in the legislative assembly. So as far as the legislation is concerned, the money bill can be introduced only in the legislative assembly, and the legislative council has to return it within 14 days. As far as the ordinary bill and a financial bill is concerned, the legislative council can delay the passage of bill for maximum 4 months, and thus the legislative council can be termed as a delaying chamber. By this, I am concluding my video for today. Thank you.